Hi, it's Lorraine the Lawyer, and I am back to break down recording and publishing contracts into sizable terms and clauses that people can understand. I think it is really, really important for artists who are trying to get their self-represented and trying to sign on with labels to understand when they're given a contract how that should break down. In starting this off, I thought it would be best that we actually take a sample contract and we have a look at it. So you will see on the screen that we have a sample music contract. And this particular one is for a label. And I would encourage you to please really tune in as I break this all down for us. Yes. All right. So the territory of this particular contract is really everywhere. It has no limitation in terms of authority for a territory, which is very interesting to note. In terms of a grant of rights, so territory number 2, grant of rights, here the musician is granting the record company all the rights embodied in the recording of the songs listed at the end of the contract. Go way down. The record company can use the musician's name and image to advertise and promote the recordings contained in the master forever. So understand this, the label is taking you forever and your music contract. Really think about that as per, versus an actual music management company that would not likely ask for full ownership of all of your work. Record labels tend to ask for that full ownership forever. The master is the actual original recording of the song that the musician records for the record company and is then held by the record company. The artist is always waiving their moral rights, which are rights that protect the personal and artistic value of the work to the artist. When the artist waives these rights, they are giving up their artistic control of the master recordings. All right, everyone. That's pretty deep. There's 2 types of copyright in songs. First, the actual song itself, composition and lyrics, and then the copyright in the actual performance of the song. So in this case, the second copyright is in the master recordings at issue in this contract. All right. So first point we covered was territory. The contractual terms are controlled everywhere. The second, the grant of rights. And now we're getting into format. This means that the record company can use any means to sell or distribute the recorded song they own, streaming service, CD, or anything that may come along later. Number 4, neighboring rights. Here, the record company is reserving the right to collect their share of neighboring rights, which are royalties paid when the song is performed in public, on streaming services, radio, TV, etc. The one twist here is that the United States actually doesn't recognize neighboring rights for territorial radio and TV-based broadcasts. So American artists are somewhat more limited in the neighboring rights royalties they collect from their European or Asian counterparts. Digital platforms, however, do collect neighboring rights in the US. Phonographic performing rights are just another name for neighboring rights. All right, taking the mystery out here, everyone, so you can really understand what you are signing. 5th, advances. Here, the artist is receiving a $500 advance right now, but that money will be paid back to the record company since the record company can withhold an equal amount of money to recoup that advance once the artist begins to generate royalties. 6, the royalty rate is the amount that the record company will keep for themselves from the artist's royalties. In this contract, for example, for all the digital downloads and digital transitions, that's not radio, TV, or live performance. Okay, so count that out. But all other platforms, the radio company will take 20% of the net income. That's important to think about because the net income is what's left over after all the expenses have been paid by the record company and may be much more different than the gross income. When the song is licensed to a third party for use, the record company will take 50% of the net income. Whoa. Next comes a somewhat interesting sentence. And this is, if you look through the sample, payment is going to be made to the artist in the currency of the head office of the company. It's worth really looking where the head office of the company is located, since that's going to be the currency you're receiving. The record company will pay the artist their royalties, which includes all the related third-party royalties collected. The section on digital phono record deliverables is worth also explanation here. In 1995, Congress got concerned that digital music, MP3s, would displace physical music like CDs or records. So Congress extended mechanical royalties, that is, royalties, defining here, collected for sales of physical copies of a song and now digital downloads, to then digital copies of songs as well. All right. So in 2001, the US Copyright Office asked if digital streaming services where the user selected a specific song were engaged in activities which would cause mechanical royalties to be paid. This question sort of lingered until 2008, when a voluntary industry agreement was hammered out that allowed mechanical royalties to be then collected from streamed songs on interactive platforms. So a little bit of history here, folks. What is reserves on goods in physical format? Here we see in this sample. This refers to actual physical recordings like records, tapes, CDs, etc. And here the rate is 30%, which means that the record company withholds up to 30% of the artist's royalty payment to ensure that the record company is compensated for any returned or unsold physical copies of the artist's work. Every 3 accounting periods, that appears to be 18 months per this contract's accounting section, this number will be revisited. Inventory will be taken to see how much was returned or unsold, and the artist will be paid what they're owed from any money that is left over. All right, so let's recap again. We have covered what the territory is, the grant of rights, format, neighboring rights, advances, the royalty rates, mechanical licenses, and now we are going to talk also about music publishing. So let's look again, one quick moment at mechanical licenses. These are licenses granted to people who want to use the artist's song in an audio-only format. This covers versions of a song being a prime example. There's a statutory rate of 9.1 cents for a song's 5 minutes or less. And this contract allows the record company to use that statutory rate for artist songs of any length. The record company is also allowed to give a discount to third parties if the record company desires that. Perhaps then, if the song will be used for a large-scale use and the record company wants to give a volume discount. All right, so let's move on to music publishing. Here, the artist in this sample is giving the record company a 50% interest in all the publishing rights of the song. So you really have to laser in on these clauses. This is a separate from the master rights detailed above when we were talking earlier. The master rights are the rights to a particular performance of the song, whereas the publishing rights of the song is an underlining lyric/music of the song. All right. Here, the music company is also taking all the rights in this sample to administer. Essentially, this is how to monetize and exploit the song to make more money. All right, so let's move on to the accounting. Number 9, twice a year within the time periods contractually specified, the artist needs to provide the record company with an invoice specifying to whom payment needs to be made. The artist may also have a CPA audit the record company, so hire a CPA at the artist's expense to ensure that all royalties have been properly paid. The artist needs, in this particular contract, needs to provide 30 days notice to the record company and can't audit more than 1 year. If an artist makes then 100, so in this contract, they're citing £100, which is interesting because this contract was actually presented to an American artist. So let's assume $100 for our purposes. So that's interesting. It looks like this contract has been borrowed, maybe potentially from a sample that was from the UK. Oh boy. The artist will be paid in the next accounting period when they make more than that account. 10, remix rights. If the artist remixes their song using the master's which the record company owns, the artist company will own and control that remix. The artist will be the one who needs to provide sample clips or vocals for the inclusion in that remix. Now, in most contracts, you have something called a boiler section, and that is where the lawyer has to laser focus in. Because a lot of the time, especially if you're dealing with a very big music label, they will try to insert lots of juicy stuff into their boilerplate. However, they will make it in a way so that they just want this always to be accepted, all of these terms. And they deem them and relay them as being standardized. So let's look through this particular contract. Number one, the artist can enter into this agreement, number one, when the master recordings are finished, there's no one else who can claim ownership or any reason to take away from the record company's ability to use them. That the record company will not be responsible for any fees or royalties due to the third party who worked on the recording. Yikes. All right, so they're not going to take responsibility for that collection. The artist represents that these people were paid a flat fee or that the artist will pay them their owed royalties without making the record company responsible for that. D, nothing in the master that the artist produced contains unlicensed content, especially unlicensed samples from other songs. Nothing in the master, the artist's name, advertising, and essentially anything that the artist does related to the master doesn't infringe on anyone else's intellectual property or violates any laws. F, if the artist is a member of a performing rights society, these are essentially groups who collect royalties. The artist will provide the record company with the proper paperwork so that the record company can work to get the royalties properly collected. If the artist fails to do this, the record company can then contact the groups collecting royalties and do it themselves by bypassing the artist. G, the artist agrees not to re-record these masters, essentially agreeing not to record the song for the record company and then turn around and record it for another label. If the artist breaches any of the above, they will indemnify the record company, including attorney fees. 12, remedies. The only remedy the artist will have is the ability to sue the record company for damages. This supposedly would stop the artist from seeking a restraining order, stop the recording company from selling or publishing the artist's work. All right, so there is the entire agreement between the record company and the artist, and no other communications or promises would control. At some future point, the artist and record company might work out a more detailed contract, but until then, this is the controlling agreement according to this sample. Also, the record company can assign, in other words, give the right to this contract to another entity to administer. So let's look at the provision to breach and cure. This is super important because it indicates that if either party believes the other side is breaching the agreement, so if you have a situation where they're breaking the contract, they have to alert the breaching party first. So they have to give notice. And that's a very, very important concept in law. Most times, you are not authorized to bring forward a lawsuit. You are not authorized to file. You're not authorized to act unless you give notice first to the other party. And that is because our courts are backlogged. And we have so many suits that they want to make sure that the parties have done their due diligence to try to see that they have resolved the conflict first. So in this particular contract, that is by registered mail, giving notice by registered mail. And the alleged breach party here has to give 30 days to stop the breach. All right, now let's look at severability. Every part of this agreement is separate. And if a court comes in and decides that something shouldn't be enforceable and removes it, that only removed parts stops in effect. So only the removed part stops being in effect. Everything else stays in effect as much as possible. All right, let's look at third-party claims, also very important. No one who isn't a party in this contract has any right to enforce it. However, under Section 13, the record company can assign this contract. So really, a third party can assert rights if the record company assign the record company's rights to them. All right, now the last concept here, which is very important and brought up in this contract, but mostly seen in many standardized contracts, is that a choice of law. This is where the agreement will be enforceable. Most good choice of law clauses will have a specific certain state law that applies, and then a certain state court that will apply, and even sometimes a certain county. And that is where the action can actually be brought. And this clause just says that the laws of the United States apply and the United States court will have your jurisdiction. So this should be much more specific because it really says that this, as I mentioned at the very beginning of this video, that the jurisdiction is everywhere. So in general, when we step away and we look at this sample contract and the kind of things that a lawyer would pull away from it, it really looks like it's a UK contract that's rewritten for the American market, where the references to solicitor-client basis in Section 11 of this contract, as well as £100 under accounting, is very super vague, and choice of law clauses, and really neighboring rights as well, being in English spelling. So looks like some attorney has taken some shortcuts in providing this to the party. All right. Thank you so much. Now, I want to move forward and really talk about another important part of this contract, which is the implications that we can bring from it. When the contract goes bad, which is very, very important to think of, because it's not so much about when the contract is actually working for you. It's more about what happens with the fallout when the contract is not properly covering the parties and conflict ensues, or just conflict ensues. So we want to really think about when the artist and manager relationship changes, when it shifts. So when does a music label contract really come into play and become super important? From the record publishing contract that got broken down, in our talk here, it's clear just how complicated this all is. And we have to keep in mind that the contract was just for one song and for a relatively small amount, $500 here. Major recording contracts can be even more entangled and get into minutia. So digital streaming, so just pause for a second. So with that past contract, we had $500 advance in an exchange. They're getting ownership pretty much of all things here. So digital streaming and digital devices have changed musicians' lives, both for the better and the worst. Originally, artists would tour and probably lose money, but they would sell physical albums and merchandise. Then enter the era of digital devices where anyone with a cell phone could bootleg a concert with both audio and video. Digital copies of albums could be illicitly downloaded by millions of users, and listeners no longer have to really buy an album to hear a song they want. The revenue stream then shifted towards artists actually losing money on their recorded music, but making money on tours. Managers had to be fast on their feet to then ensure that their represented musicians played the best venues. Also, where an album's royalties would pay a manager a steady income stream for years, with declining music sales and tour revenue being the prime income now stream, managers found themselves being paid a large sum during a tour, but then that stream dried up once the tour is then over. So standard management contracts take about 10 to 20% of an artist's gross take. That's a really significant or fair chunk out of an artist's take, especially when you consider that the number is of the gross and not the net artist take. A number of high-profile artists have decided to keep their management in-house and essentially do it themselves. And that, I will say, may be one of the main reasons why. So let's look at Bruno Mars. Let's look at the situation of Bruno Mars, where he is going it alone. Bruno Mars is an absolute prime example of this. In 2013, his manager at the time, Brandon Creed, sold half interest in Creed's company to Live Nation's Artist Nation. Creed's take in this sale was several $1 million, and he neglected to mention this sale to Bruno. In 2013, when Bruno Mars found out about the general nature of the sale, he absolutely objected to it. Primarily, Creed monetized his managerial relationship with Mars to profit for himself without telling Mars, or perhaps even offering him some degree of compensation. Because of this, Mars felt Creed and kept all his management in-house with a staff that he hired and he controlled. Smart. It's worth noting that Bruno Mars didn't leave his manager because he didn't like the contractual terms. It seemed more that it was out of disapproval of the way that Creed handled the business deal without keeping Mars in the loop. On the other hand, Bruno Mars had a lot going for him that the average musician just doesn't. While most managers are busy building a musician's career, when you're as famous as Bruno Mars, you don't need a manager to promote you per se. Some would say. You have the name recognition to get the prime promoters to come to you directly, rather than having to court them. A manager with an artist as big as Bruno Mars is more focused on just maintaining things as they are, rather than having to build the brand into success. When an artist with the name recognition takes their management in-house, they need people to just focus on the day-to-day running of operations, which is much different than building a upcoming artist. Also, while Bruno Mars can now take a cut, 10 to 20% management fees, he has the cost of hiring in-house management. While that may save some money, it's debatable how much that will be in the long run. What might be more enticing reason then for a big name artist to ditch their management is to have more creative control over their artistic vision and career. Keep management in-house and it's all yours now. We're also aware that in the rap and hip hop genre, artists there who keep their management in-house can have more influence as a self-made mogul. Who did it themselves and built their own empire. There's a respect there. While in other genres of music, that might not be as important. All right, so let's look when the contract goes bad. Number one, bankruptcy. Music is full of examples of artists wanting to break their contracts completely or at least renegotiate this. This can take a few forms. The artist can declare bankruptcy, saying that they're literally broke, causing contracts to be renegotiated with somewhat more favorable terms, often with their record company protesting. This route was followed by Tom Petty in 1979, 43 years ago, Toni Braxton, 1998, and TLC in 1996. All of these ended up with the artist getting a nicely renegotiated contract. All right, so we just talked about when there's bankruptcy and the contract is going bad. All right, how about when the contract is going bad when more rap stars than I can name? So a number of rap artists have taken to social media to express their distaste with how their record company has dealt with them. This kind of social pressure has in some cases produced results. Lupe Fiasco versus Atlantic Records, Azealia Banks versus Universal Records. Oftentimes, rap stars will also begin to make not so veiled references in their music to their alleged exploitation by the record company. This degree of social pressure has worked and results in a renegotiation of terms. The common thread in all of this is that even when there is a lawsuit, no matter how publicized, more often than not, it will settle, and settle with confidential terms. Rarely do these things go to trial. Everyone knows where the money is at. An artist caught up in a contractual dispute with a label isn't producing any new material, and then no one is making money. So settling is generally financially expedient option to then go for. All right. Let's look at the Keisha situation and what I would call it scorched earth way. Starting in about 2013, rumors started on a social media that Keisha was being held back in her career and artistic vision by her longtime manager, Dr. Luke. Keisha's mother publicly stated that she hoped Keisha could get out of her contract and that she would be dropped from RCA Records. In October 2014, Keisha sued her longtime producer, Dr. Luke, for infliction of emotional distress, gender bias, hate crimes, and employment discrimination. Among the claims were that Dr. Luke had sexually abused her, causing, among other things, that Keisha to develop an eating disorder, and Keisha then asked that her contract with Dr. Luke be broken. Dr. Luke promptly responded with a defamation suit against Keisha, and that was filed in New York in December 2014. One of Keisha's demands was an injunction prohibiting Dr. Luke from working with her, thus Keisha giving greater artistic freedom in her own career. Allegations that the vast majority of Keisha's songs for her previous album with Dr. Luke had been scrapped by Dr. Luke's order had been floating around since about 2014. The judge then denied the preliminary injunction in 2016, noting that Keisha's contract had been carefully negotiated by both parties, and that Dr. Luke had apparently invested $60 million in Keisha's career, and that in 2011, Keisha had testified under oath in deposition that Dr. Luke had never actually sexually abused her, and that Dr. Luke had already offered to allow Keisha to record and fulfill her contract without further involvement. Wow. As of April 2016, all of Keisha's sexual assault, harassment, and gender violence claims were dismissed for lack of evidence, please note, falling outside of then the statute of limitations and failure to show that any behavior Dr. Luke engaged in was driven by a specific hatred towards women. Further, the claims about infliction of emotional distress were denied because comments about a singer's physical appearance or ability as an artist doesn't rise to extreme, outrageous conduct intolerable in civilized society, as noted in this case. In August 2016, Keisha dropped her California-based sexual assault claims, focusing only on remaining claims in New York. As then appeals since the original claims were dismissed in April 6, 2016. That same month, Keisha released a single and later an album on Kimosebe, Dr. Luke's record label, Kimosebe. In February 2020, the appeals court ruled that Keisha breached her recording contract with KMI, Dr. Luke's record label, by making false claims and defamatory statements about other alleged abuse by Dr. Luke that had subjected other female artists too, and ordered Keisha to pay about $375,000 in prejudgment interest to Dr. Luke. Currently, Dr. Luke's defamation suit is still winding through the courts. Honestly, another subject in and of itself, including free speech laws and public and private figure distinctions. Meanwhile, Keisha has moved on to other projects, branching out to television as well. So where does that leave Keisha? There was a 5-year hiatus in her music from 2012 to 2017 while she fought all of this out in court. Does this help Keisha the artist? That is very doubtful. There's a lot of emotionally charged allegations in all of this. And without casting any judgment, the easier way might have been just to ride this contract out to its end, instead of making allegations that she did. The only people that got richer here were the record executives who were receiving the royalties from her already recorded music. Unlike the examples in rap music, it seems that personal acrimony may have been clouded business judgment in this case. So some final thoughts from Lorraine the Lawyer as we sit back and think about what we just discussed. So where does this leave everything? It leaves us with obvious case of the record company has the power, and oftentimes the musician is the party not in control of the situation. As the recording contract we looked at shows, there's a lot of complicated terms and conditions with royalties that a number of artists probably won't understand. They're at the mercy of their lawyer to negotiate the best deal, although that's not always the case when a major label is involved, since that label holds all the bargaining chips. One is entitled to wonder how an artist from overseas, an O1 visa, for example, recipient, would deal with this situation. If you have an artist from another country, even an established artist internationally, dealing with an American label, American contract law, and if need, the American justice system, just think about this. The O1 visa holder is here for a limited purpose, a limited duration, and what happens if they're offered a recording contract here during that time? What happens? A whirlwind tour, contract shoved in their face, large advance, and a failure to read the fine print or fully understand US law may dispel disaster down the road for them. Something to think about, and especially when thinking about making an attorney, an entertainment attorney like ourselves, a very key part of your legal team. So what is the moral of the story here? What is the moral of the story here? Get a lawyer. Get a good lawyer. Get a good lawyer who understands royalties, because in the end, that's what every one of these agreements seems to come down to. Money makes everything go round. Lorraine the Lawyer, thank you so much for joining me today.